Welcome to another Flip video lesson. Today we are going to finish our small mini-series on the different branches of government. So we'll be talking about the judicial branch, which is the third of the three branches of government. This is, by the way, for lesson 9.5. So let's get started, shall we? The judicial branch finds its responsibilities and powers in the third article of the Constitution. And really the primary job of the judicial branch is to protect the Constitution. In other words, it determines if laws that are created by the legislative branch, which is Congress, and then enforced by the executive branch, which is the president and his or her cabinet, follow the Constitution. And it does that in three different ways. First off, the judicial branch resolves disputes that involve federal laws. For example, I did some research and there were some court cases this last year having to do with education. There were some court cases having to do with trademarks, people feeling like other people were stealing their ideas. All those have to do with federal laws. The judicial branch also resolves disputes involving federal and state governments if they're arguing over each other. A big one right now has to do with immigration laws and not allowing certain immigrants into our country. Finally, the Supreme Court, or the judicial branch, tries people for breaking national laws. So if there's people who break laws that the federal government put in place, it is the Supreme Court that hears that case. The judges for the judicial branch are appointed by the president and then confirmed by the Senate. So whoever our president is, he or she will choose people, and then Senate will say whether or not these people could be good judges. The president, I might say, Mr. Mint, I would like you to be part of the Supreme Court in the judicial branch. Then Mr. Mint would have to go before the Senate, and answer a lot of questions. The Senate then would let Mr. Mint know if he could be on the Supreme Court. Well, Miss Senator, can he be on the Supreme Court? Uh-oh. Outlook not so good for Mr. Mint on the Supreme Court. Within the judicial branch, we have what's called the federal court system. And there are three levels to this court system. Something about the number 3 today, isn't there, folks? The first level, which is also the lowest, is made up of the district courts. Now this map right here that I found online shows only 11 what's called regional circuits, when in fact, based upon a US government website, there are actually 12. So there are in fact 12 regional circuits for these lower courts. Within each of these regional circuits, we have what's called districts. And in all, there are 94 district courts that are split up into these 12 different regional circuits. These are the first ones to hear any court cases having to do with federal laws. After the district courts, there is what's called the Court of Appeals. And there are in fact 13 Court of Appeals. Finally, the very highest and most powerful of all of our federal courts is the Supreme Court. The following two slides are going to go a little more in depth into these three different levels. We're going to start talking first about the Supreme Court. Let's talk about the Supreme Court now, shall we? Now, the Supreme Court is an appeals type court. In fact, the Supreme Court is the only court that has been specifically required from the Constitution. Now, when I say an appeals type court, what I mean is this. When you make an appeal in the courts, you are asking a higher court to change the outcome or ruling of a lower court. So back to my very previous slide here. Thank you for that bad grammar, Mr. Volkman. If you went to the Supreme Court, what you're really saying is that you didn't like the decision that the Court of Appeals made and you want to get it changed. With this idea, the Supreme Court doesn't hold trials to say who's guilty and who's not guilty. But what they do is they interpret the meaning of the law and they say how that law should be applied based upon the Constitution. So if we go back to one of my examples, I was talking about education. So there was a court case in the Supreme Court earlier this year with this family who had a son who had autism, and the school district he was in originally said that they could not help him. So they sent this young boy to go to a private school. Long story short, the family decided that this young boy was doing better at the public school, but the bigger problem was the fact that the public school sent the boy over, and if I understood this correctly, without really the parents' permission. So they went to the Supreme Court to try to have the public school pay the private school's tuition, because public school is free through taxes. Private schools aren't. You have to pay out of pocket. So that is one example where the Supreme Court has to decide on what to do with this court case based upon what's already written in the Constitution. Finally, all the lower courts, like the Court of Appeals and the district courts, they have to make their rulings based upon whatever the Supreme Court has said in all of its rulings throughout the history of our country. Now, about the lower courts in our judicial branch system. First, let's talk about the district court, which are the lowest of the three levels. They're the lowest, in fact, because they're the first to hear disputes involving federal law. These are the people, or these are the courts, I should say, that decide who is correct in a case through the Constitution and previous Supreme Court rulings. In these district courts, the judge runs the trial, but it's the jury who decides the verdict. Now, if someone doesn't like the decision that the district court makes, they can then go to the Court of Appeals. Now, the Court of Appeals doesn't have a jury. It has about 3 judges or so. And these people determine whether the original trial was fair or not under the laws that Congress and the executive branch have put into place, but they also decide if they're fair under our Constitution. They don't say whether or not someone's guilty or if someone's innocent. If the defense loses in the Court of Appeals and they don't get their way still, they can then take their case to the Supreme Court. But it's not that easy, because they have to send in a request to be heard by the Supreme Court. And it can be denied. In fact, there's been approximately 7,500 requests to the Supreme Court, and they've taken only less than 150 of these. They only take the most important cases. Thank you for listening and watching to another Flip video. Please go to Edmodo to answer the questions, and don't be afraid to rewatch the video again to help you answer the questions, because that's what Flip videos are for, to watch more than once. Thank you.